Here to discuss it, trial attorney Lateef Gray in Oakland, California, and in Detroit, trial attorney Michael Jaafar. Welcome, both of you. Good afternoon. Michael, the October 2nd, let's start it there. Likely not going to happen, especially if the state comes in and says we are seeking the death penalty.
Oh, yeah, absolutely. October 2nd is only, 4 months away. This is a trial of grave magnitude. The nation is going to be very interested in it. 4, college students were killed and murdered, and he went to Pennsylvania. He was, arrested in his parents' house. It took them 6 months to extradite him from to Pennsylvania and get him to this point. So the trial is 4 months later, and it took them about 5 months to get him to this point. I would put the chances of a trial of happening on October 2nd at around 5%.
Lateef, according to our Chanley Painter, who was in the courtroom, Kohlberger at one point when first walking in gave a quick glance into the gallery, but otherwise, as we watched, it was pretty much straightforward, not looking back. Family members were in the gallery, the Gonzalez family, Maddie Mogen's family there. Anything stand out to you in terms of his appearance, his, the fact that he elected to stand silent instead of entering the not guilty plea, which we expected?
Well, the fact that he didn't enter the not guilty plea, or his attorney didn't enter the not guilty plea, is a little bit different. Ordinarily, in these circumstances, when a client is entering a plea, whether it be guilty or not guilty, the attorney lets the court know in advance what the client will be doing. So the fact that his attorney didn't enter a not guilty plea on his behalf is a little bit different. The fact that he didn't look around and stayed straight ahead, that might be at the advice of counsel. I know usually when we come into court, we tell our clients, don't look around, look straight ahead, and let the court know that you're here for serious business.
The Parkland shooter, Nicholas Cruz, did the same thing. In Florida, it's called, instead of saying the defendant stands silent, in Florida, it's the defendant stands mute. And that's what Nicholas Cruz did, and the mentality behind that was that it serves as one of the mitigators, and that is remorse, because we know that Nicholas Cruz admitted to what he did and wanted to enter into a plea agreement with the state to avoid trial in return of dropping the death penalty. He would plead guilty. They turned that down. He ends up pleading guilty anyway, and they have the penalty phase where eventually he was not sent to death row. Do you think that maybe, Michael, that's the angle, that he is going to eventually plead guilty here, that might be behind why he chose to, quote, stand silent?
That could be. He clearly had a discussion with his attorney. This was an intentional act on their part, right? This is part of a larger plan and strategy that him and his counsel have put together. It could just be that his counsel told him the only way out of the death penalty is through this judge. It's not through a jury, it's through this judge. You're going to have to prove to this judge that you are remorseful, and this might be the beginnings of that play. We're going to find out soon, and for all we know, maybe that's why they put the trial date so soon, because maybe the court knows something we don't know. There is a gag order on this, so they might know something they definitely know something we don't know, and that thing might just be that this kid is going to end up pleading out.
But do you think, Lateef, the state of Idaho agree to a plea agreement, given the fact that they do have the death penalty on the books, and this, I can't imagine a crime worse, if prosecutors and family don't want to enter into any sort of plea, correct?
Yeah, it just depends. I could see the state entering into a plea with this gentleman based on the fact that they don't want to put the families through a lengthy trial where they'd have to sit there every day. They may have to testify. They may have to hear evidence that is just gruesome. So I could see the state offering a plea in exchange for keeping the families from being further traumatized by having to listen and sit through a lengthy trial.
if that's where the family wants to go, Michael, some families do want that process. They want the maximum penalty allowed by law as a point where they feel as though they're fighting for their loved one.
Yeah, I mean, the victim's advocate definitely are probably involved in this process, right? If we're gearing up for a plea and the court knows that, and the attorneys have, because the attorneys take a sidebar with the judge, right? And they have open conversations with the judge. They don't admit to fault or anything, but they've telegraphed if they're going to plea. I would assume their attorneys have telegraphed this to the judge. The victim's advocate must be involved, and the families of these 4 kids, they're going to be heard by this judge, and he's going to care more about their opinion than the opinion of the defendant, if in fact he does plead guilty, and if in fact he did in fact do this. So the families are going to play a big part in sentencing. They definitely are.
The probable cause affidavit laid out the state's case in such a fashion that kind of really didn't need the prelim for the public disclosure of the strength of the case, Lateef, because it's there. I mean, they have him, they're tracking his vehicle, they're tracking his cell phone, and most importantly, the killer leaves behind a knife sheath, and guess what? This guy's DNA is on the snap of that knife sheath. It seems as though while he said through an attorney after his arrest that he looked forward to clearing his name, that enough time has gone by for a PhD student to connect the dots that, ruh-roh, I'm done. You agree, Lateef?
Well, I agree that there's a lot of evidence. Him saying he wants to clear his name, I mean, that's just, he has to say that at that point. I mean, he can't come in and say, I'm pleading guilty from the beginning of the case. So him saying he wants to clear his name and wants to fight the case, I expected him to do that. The fact that they've gone by way of a grand jury indictment lets me know that the prosecutor wants to get this case moving and wants to get some sort of progress made, either be a plea or taking it to trial.
Yeah, and that part of the equation there too was the fact that the defense wanted to, or they filed a motion for, they issued a subpoena for the 4th roommate, and they asked the court to require that individual to testify at the preliminary hearing. And it was shortly after that was litigated that the state went to the grand jury and they vacated the prelim because they didn't need it because a grand jury indicted him. So this is a 3-part process, very bizarre sort of thing happening today. You have the arraignment, which is, it was done. Now there are 2 other things on the docket, if you will, but they've taken breaks in between them. So next up is the scheduling conference on the gag order. You remember the Gonzalez family is, through their attorneys, basically asking the court to separate the families from this gag order, and they want the ability to discuss the case, and they believe that that's very important. So they're going to deal with that. And then there's going to be a 3rd hearing, a motion hearing on a defense motion to compel. Well, you know, you had this stay silent thing going on, Michael. Everything else leads one to believe that Kohlberger and his team are going to fight this, and just because of the movements that they've made from a legal standpoint, including today with this motion to compel for discovery. So I guess we shouldn't read too much into his standing silent thing and think, oh, I bet he's going to plead guilty. Every other indicator, right, is that they're going to fight this tooth and nail.
Yeah, let me opine on that. So we just witnessed a case last week on this channel where the attorneys did a phenomenal job defending the person all the way up until the end. And then that person, Zeiler, took the stand in his own defense. And then 20 minutes later, his attorney quit the case. He was ethically required to quit the case. He actually had to withdraw from representing his client after spending over a year getting him to that point, and did an awesome job, right? And so the reason I bring that up is because the attorneys in this case, like all attorneys in all cases, have an ethical duty. The defense attorneys have an ethical duty to do everything they possibly can to challenge all the evidence, challenge all the witnesses, turn every stone over. Otherwise, their license is on the line, right? So they might have an excellent client or a crazy client. We know nothing about this defendant, right? But no matter what type of defendant he is, his attorneys are required to do exactly what they're doing now, even if he tells them that he wants to plea. What if he tells them, I want to plea, and then he changes his mind 2 months later or a month later? They will lose their licenses if they miss deadlines or miss the opportunity to challenge evidence. They have to do everything they possibly can. And at the end of the day, if their client is found guilty, the first thing he's going to do in his appeal is he's going to claim ineffective assistance of counsel. And if they really did ineffectively assist him, they're not going to be attorneys very much longer. So when we see them taking these movements, I read it as this is what they're supposed to do, but we're going to see whether or not it works.
Yeah, they're doing their job and doing it to the best of their abilities. Let's get a break in here. We are expecting that second hearing to begin. Michael Jaafar and Lateef Gray have been watching along with us. Michael, the Gonzalez family is clearly one of those families that are ready to go to battle, if you will. You know, there's different people have different reactions. Steve especially is very keen on making his presence felt, and that strategy of trying to fill the courtroom and make Kohlberger feel uncomfortable. Is that something you've encountered before? I mean, there are different reactions, right? Because this is a horrible process that all of these individuals for all four of these families are going through.
This is going to have a dramatic impact on the jury, right? So this isn't really just for the cameras or for the media or anything like that. There's going to be a jury that's going to have to decide this case if, in fact, this case goes to trial, right? And so their presence in the courtroom is going to be palpable. It's going to be known. It's going to be felt by the jury. It's actually going to have a negative effect for the defendant. I'm not saying he deserves more. He might not. But their presence is going to make the jury feel very uncomfortable, and it's going to make the jury feel like it's going to be an impact against the defendant, right? At the end of the day, this is the unfortunate thing about our system. This is the beautiful thing about our system, which is that you see this gag order. People want to talk about this case. People want to try this case before it's actually tried. And so I could see the judge's wisdom behind putting this gag order. It's uncomfortable for us because we want to talk about the case. We want to know a little bit more about the case. But this is exactly why, because he saw that the family members are going to go out there without a gag order. They are going to basically let everybody in the country know that this person murdered their beautiful, sweet kids. And the case is going to be over before it actually progresses. So it's unfortunate. You see the pictures of these beautiful kids. They were robbed of their lives. If in fact this defendant did it, he deserves the worst. But what the judge is trying to do is try to say, listen, there's a process, there's a system, we have to go through it. I understand everybody wants red meat, but we've got to go through this system. And so I need everybody to just calm down. If they're in this courtroom and they make an actual dramatic impact and they yell, they scream, they're going to be out of that courtroom. So we're going to see what happens.
The judge has said I'm getting some notes from the courtroom here, the 27th of June at 10 a.m. to talk about cameras and then also the gag order. But then Shannon Gray apparently stood up and basically said that he wants this motion to amend and clarify. It's different, and he wants a hearing much sooner. He would like it by the end of this week. The judge responds, can you do June 9th? Better to do it all at the same time. Could be ready by June 9th. So Shannon Gray, who represents the Gonzalez family in the courtroom this morning, representing them in the well there, and he's pushing this forward, and sort of to that theme, Lateef, of this is one of those families that is not going to just sit back and be told to just let the process go. They're pushing the envelope, which is their right, and we're seeing it play out here in the courtroom right now.
Yeah, they're a very aggressive family, and by aggressive, I mean they want to get their point across, which is that their loved one was taken from them, and they want everybody to know about it. And especially they want the defendant to know about it. So I understand their perspective. I understand where they're coming from. If this happened to me, I'd want the world to know about it. So I definitely understand where they're coming from. Yeah.
Michael, the bottom line here, this October 2nd trial date, it seems that there's just no way that that's going to go. There's a 60-day window for the state to decide whether or not to go for the death penalty. If which we expect they will, they declare that they'll pursue the death penalty, it changes the game, does it not? Just inherently, because of the magnitude of a capital case opposed to a regular murder case, if you will.
Anytime the state takes someone's life consciously, it's a big deal, right? We're one of the few civilized countries that have the death penalty, and we've had it for a long time. Some states don't have it, obviously. Whenever a state decides to take someone's life, it takes the entire specter of the case and the duties and the responsibilities and the timelines. It takes it and blows it out of proportion. People hear about many, many years that go by after a person's found guilty and after the death penalty is given. So we're not going to see an October 2nd trial date if the state goes for the death penalty. And I don't see how they can avoid going for the death penalty. You have the death of 4 beautiful young college kids, innocent kids. If this person did in fact do it, I can't see, if this is not a death penalty case, what is? He's a PhD student. He knows better. He's not chewing his forearm in front of the cameras, right? So he's clearly a person who was in control of himself, and he killed. If in fact he did it, he would be found guilty of killing 4 young people at the beginning of their lives, right? They have to go for the death penalty, and so when they do that, they're not going to have an October 2nd trial date. It's just not possible.
Oh boy, I'm just getting more notes out of the courtroom. Shannon Gray is going at it here with this judge. The judge now set, instead of the 27th, the June 9th, because Shannon Gray wanted this clarification and adjustment to the order. And his response to the June 9th was to the judge, this is your gag order. If the court does not want to make modifications in my motions might end up getting moved. The Supreme Court gave guidance which gave great weight to my motion. It goes on and on, but obviously he is fighting this tooth and nail in front of the judge and in front of Brian Koberger, who is in court. We're going to get a break in here. Chief Gray is here with us. He's in Oakland, California. He's a Bay Area attorney, and in Detroit, trial attorney Michael Jaafar is with us. They call him Big Case Mike because he's always on the big ones. Mike, when you look at the evidence stacked up that we know of from the probable cause affidavit in this case, what stands out to you? All right, I'm going to take away the DNA caught on the knife sheath, because that seems to be, if it's legit and the defense is unable to hammer in some doubt on that one with an expert, because if that's legit, if his DNA is on this knife sheath left at the crime scene, on the snap, the button there, I think it's game over. But other than that, what is it? The Hyundai Elantra, what is it that stands out to you as the most compelling in terms of from a jury's perspective?
It's the cell phone data, right? So, we grew up in a world where you could not present cell phone data and data from a watch to place somebody at the scene of a crime. Now, this has become a thing in the past decade, right? So people have these smartwatches. Everybody has a cell phone, right? I remember back in the days when I was in college, nobody had a cell phone, right? We used to have beepers, and you could not place someone with a beeper, but now you could place someone with a cell phone. The most compelling evidence to me is the cell phone data, right? And showing where the person was, and the Hyundai Elantra and all of that. That in conjunction with the knife, as a pundit, I'm here in my capacity as a pundit on this case, right? Not as an attorney. And so as a pundit, I would look at this and say, he's cooked, right? I don't see how you can avoid it. He had the motive. He was a loner. He was friends with these people. He knew these people. He has his DNA evidence on the knife. They were stabbed to death. That's the most compelling evidence. So as a pundit, I think he's cooked, right? I don't see how they can cast doubt. Now, what they could do and what the attorneys can do if they fight this case is say, look, he was there. He was definitely at the scene of the crime. His DNA evidence was on that knife, but there was somebody else who did it. Or they might even claim, I don't know how you could allege self-defense in this case, but they would have to say that there was somebody else there, somebody else stabbed them, somebody else did this, he was just coincidentally there. That's the only way you can do it. If you're dealing with one murder, that's one thing. You're dealing with 4 murders, right? So it's going to be almost impossible. Maybe this is one of the cases that pleads out. A lot of these cases do plead out, right? Not a lot of these cases go to trial. This might be one of them. You see the pictures of these beautiful kids. It's insane. It's just disgusting. So I just don't see how would be the most difficult assignment if I was put on this case as a public defender. This would be the most difficult assignment I could possibly have. I can't see a more difficult case to defend than this.
Lateef, what do you do when you have a case that is difficult to defend because of the facts, because of maybe the defendant? How do you handle that? It's your job.
You give it your best effort. I mean, and it seems like his attorneys are doing that. The motion to compel, in which they're asking for all the discovery, that's a good start. But when you have tough cases like this, you just have to fight them. You go into them realizing that this is a tough fight. The odds are stacked up against you, but you do everything you would do in all the other cases that you think you could actually win. So it's a tough case. His attorneys seem like they're putting forth the effort. But when you have cases like this, you just do all the legwork you can. You interview witnesses, you do whatever you can, and you leave no stone unturned so that if your client is convicted, you can look back and say, I did everything I could do to represent him properly.
Michael, the families, the indication we get from the Gonzalez family is that they do want the state to pursue the death penalty. We both know that is a different ballgame. And what I don't think a lot of families do know is that it's excruciating. If your loved one is murdered and the individual is sentenced to death, you have a life. You have decades of hearings and attorneys that are there, that have dedicated their lives because they're against the death penalty to try to get their clients off the death row. And I witnessed an execution at San Quentin at one point, and I had interviewed the family members, and it was 18 years afterwards, and they said if they would have known what they were in for, they would have wished that the death penalty wasn't on the table, because every few years there were new crops of attorneys coming in to say how great this guy was. They relitigated the case over and over again. How important is it for prosecutors to give, and it's nearly impossible to really let them know, but give them a sense of the road ahead in a death case? Because you talked about it before. It's a different ballgame. The rules are changed, and the appeals are there. They're paid for by taxpayers, and the victim family members have to relive it for decades.
So the family members at this point, I don't see how they can be dissuaded from the death penalty because they don't have this experience, right? The prosecutors are going to explain everything that you just said. You gave a beautiful dissertation of how this process works, and you've witnessed one. I've never witnessed one. I've seen it on TV, right? So the prosecutors are going to tread carefully in explaining this to the family, but I don't see how the family can be dissuaded because you have 4, right? You have 4 families. Right. And so at the end of the day, the families, in their mind, they want to make this man uncomfortable. They want to put him through this, and they want to sit in a chair. They want to be invited one day in the morning, 10 years from now, 15 years from now. They want to sit in a chair, and they want to have this young man. At this point, in 15 years, he'll only be 43 years old. They want to see him brought into the room and put to death, and they want to look at him while he dies. Right. This is a very visceral, in-your-face type of situation. This is the worst of us, the worst of our society, worst of our culture, worst of our people as human beings, right? To stab, so he didn't shoot them, he didn't poison them, he stabbed them. He got close up and he stabbed these people. And so the family wants him to put to death, but you're right, the prosecutors are gonna have to try to explain it to them. At the end of the day, it's not their decision, but prosecutors always defer to the family on this.
They sure do. Lateef Gray, Michael Jaafar, thank you so much for helping us out here as we continue our coverage of Bryan Kohberger in court. We're going to get a break in here.
No mistake. Today we're talking about Kohberger, but it's about those 4 victims. Let's welcome our guests for this hour. Joining me right now is trial attorney Lateef Gray in Oakland, California, and in Chicago, Illinois, trial attorney Michael Jaafar. Thank you for staying with us for this hour, this special coverage of the Kohberger hearings. First off, let me get your response, Michael, to what we've seen so far today, that the fact that he didn't address the judge, he had his attorney do it on his behalf and pleading not guilty. Have you seen that before? Is that uncommon? Is that common?
It's uncommon, but I've seen it before. It happens. Sometimes some people stand mute. Sometimes some people have their the court put in the plea for them. It's uncommon, but it happens. There's a number of reasons why that would happen. One of the reasons might be just for him to be a little bit more contrite, and they may be gearing up for a plea. This is just my educated guess. They may be gearing up for a plea. They may not be gearing up for a plea. But at the end of the day, it's more of a non-issue in my opinion. The big issue is obviously what he's being charged with. He did in fact put in a non-guilty plea, even though the court put it in for him. He's taking a position. We're going to see where that goes. It might go several ways, but one of the guesses is he may be gearing up for a plea. But he's clearly coherent. So clearly, the thing that makes this odd is he's a coherent person, so he knew how to say the words not guilty. The fact that he chose not to do it, it was intentional, but my guess is it might be because he might be gearing up for a plea.
But Lateef, we're also facing someone or dealing with someone that is a criminology PhD student. Are we already seeing how different this is going to play out?
No, I don't think so. I mean, here in California, it's customary for the attorney to enter the plea on his or her client's behalf. So I don't see any sort of gamesmanship from that perspective. So I would say no, that we shouldn't look too much into that. The fact that he pled not guilty, I expected that. Even in cases where the evidence may seem overwhelming, we ordinarily don't come in and plead guilty at arraignment.
And the follow-up question with that, what should we expect next in all of this? I mean, the defense attorney said that they wanted a trial date set for the very outset of a speedy trial. Is this going to get punted, especially if Lateef, they do seek the death penalty, prosecutors?
I don't see this going to trial by October, especially if the death penalty is instituted. Because I think he may be entitled to another attorney if the death penalty is instituted. So if they do that, it's going to start a whole process where he possibly gets another attorney, and it's going to take a while before that attorney gets up to speed. So no, I don't see this going to trial by October 2nd.
All right, and in case you're just joining us right now, there is just so many different facets of this case and such a broad timeline. Today, we want to thank our guests, Lateef Gray and Michael Jaafar, for joining us this hour. And